GPS monitor. That include a GPS monitor. It can include house arrest. It could include a number of factors. It could include court supervised release, which means you have to come in. It's as if you're on probation before your case is concluded. So there are a number of different provisions or requirements that can go along with your bond. The tough part, of course, is figuring out what's the appropriate bond. And that's where the sort of the push and pull comes in, because oftentimes you have two people in front of you. You have the defense counsel perhaps arguing for no bond or a personal bond, and you have the prosecutor arguing for a higher bond or something to that nature. And as a judge, we just have to make the decision based upon the facts in front of you. And of course, we have to look at what they can afford, because if it's too high, it's the equivalent of no bond.
Well, you bring up a good point, Judge Cassandra Collier-Williams, excessive bonds. And we all know that via the Ohio Constitution, as well as the 8th Amendment to the United States Constitution, that excessive bails are prohibited. So when you look at a bond, we see it all the time in the media, bond set at $3 million. Walk us through, if you would, Judge Jones, what goes through your mind in terms of the type of case involved, the monetary amount of $3 million, and what factors do you look at pursuant to Criminal Rule 46, and what is the analysis that goes through your mind?
You're on mute.
You're on mute.
Sorry about that. All right, so the first thought that goes through my mind is when I'm in the arraignment room and someone and the state's asking for a $3 million bond, I look over, note that the person is being represented by the public defender's office in some cases, or they are needing counsel to be appointed. So without asking any financial questions at all, I understand that what the state's actually asking for is the person to be detained. Really, $3 million bond is the equivalent of no bond. So I think before we really can dig into the amount of bond that is appropriate for that person, I need to get an understanding of whether the individual is eligible for bond at all. So I look at it as a two-part step, a two-part process. First, I make a determination of whether the person is a danger to the community, whether they can exist in the community with any conditions that are non-financial, like if the person has a substance abuse issue, putting them in treatment, inpatient treatment somewhere, or a CBCF or some other secured location that's not the county jail, pending the outcome of their trial or successful completion of treatment, or non-financial conditions like that. And then I make a determination once I've figured out that they are eligible to be in the community and not pose a danger with non-financial conditions, of the amount of bond. And that's when I look at their income. And I think we've got to look at it as a two-step process under Criminal Rule 46.
Judge Emanuela Groves, would you agree with that? And if so, can you think of any cases or scenarios that you've actually personally been involved in your current capacity or beforehand concerning excessive bonds and your experiences in the arraignment room?
Yeah, certainly I agree with what Judge Jones has already indicated. And you know, the challenges, and so when we talk about bail, it's not that we don't care about safety. It's just that we recognize that there are additional tools in the toolbox to ensure safety and also the person's presence. I was a municipal court judge for 18 years, and I think one case in particular that really stood out to me and that showed how it was supposed to work, but that was because you have to have the ability to listen to both sides, was that there was a serious child endangering charge, the three-month-old baby in intensive care. And of course, we get alarmed because we're like, oh my God. And so, but also look at the defendants, no criminal record, parents, and here the baby is in the hospital. Initially went from the discussion, I thought, okay, 5,000 on criminal record, and the prosecutor jumps in, judge, baby's in serious condition, and then I'm like, oh my God, 50,000, but nothing about, you know, whether or not the person is going to come back to court. And then the public defender doing her job said, hold on a minute, what just happened here? Which caused me to readjust and really look at, okay, what are the facts? I'm like, well, Mr. Prosecutor, what did they do? Tell me what they did. I understand the baby is in the hospital, but what did these parents do to cause those injuries? And they weren't able to do that. And so I gave a personal bond. Now, certainly I was concerned if that was going to end up in the newspaper, but it didn't. And as I followed the case 3 months later, the case was dismissed. So just think, if I had yielded to that $50,000 bond and they didn't have it, the baby would be alone in the hospital without their parents. And they would have been in jail for 3 months unless they were able to make that bond. And so the way the process is supposed to work is the way that it did, I think, in that instance. And so it is to ensure the safety. And and also if there was a concern of safety, it could have been a no contact order, it could have been other conditions that could have been imposed. And I think that that's what we have to do as judges, is to be very mindful. Yeah, the facts can be discerning, but we also have to give the balance and also make sure that the rights of the defendants are protected and that the community is safe. And there are measures that we can take to ensure that safety. One of the things when Judge Adrian helped create the bond reform in our court, give them a GPS. Let's put some restrictions and know where they are, know where they were, but put some no contact orders. So there are some tools to help. And when you give the bond so high, like the $3 million that you mentioned, it really is a subterfuge to say the person should not get out. And there's a process in which to do that. And that means that there should be a hearing. And so that we're not just throwing dollars out, but we make sure that you don't even put a dollar amount, because the fact can be, under those circumstances, or the feeling can be, there's not enough money that you can post to ensure the safety of this community. So we're not even going to put a dollar amount. There's no bond.
Well, I think you bring up an interesting point, that a lot of the arguments have been that the bail system as we currently know it has disproportionately affected those who cannot afford to post bond. Therefore, those same individuals disproportionately, which affects a lot of our African-American community and other minorities and other communities that are underserved. So I pose this question to the panel.
Can I jump in for a second,
Sure.
Ross?
Mhm.
So a question that was posed in the chat that goes directly to this point.
Okay.
What people need to understand, first and foremost, is that the law as it's currently written, the criminal rules as they are currently written, the constitutions as they are currently written, put a presumption that you should be released on your own recognizance, that is a personal bond, where you sign your name and promise to come to court. You know, so if that's what the presumption is, then you have to wonder how it is that we end up with these $3 million bonds, these $1 million bonds, unless you can establish, you know, really, unless you can establish that this person is a risk either to themselves, to the community, or of not showing up when they're supposed to. You aren't even supposed to have really any conditions. The conditions come on when it can be established that you have some kind of feeling that a person is not going to comply, is going to end up either hurting somebody else, hurting themselves, or being a flight risk. If you can't have that kind of information in front of you, then your default position is supposed to be giving people personal bond.
Well, let's talk about this for a minute, because let's walk our audience through a typical situation where a person is arrested by our local authorities, and they are taken before arrested, put in jail, and then there's a bond set. For those who can post a bond at the police station prior to even seeing a judge, they're out, if I understand what you're saying.
That's right.
But for those who cannot post $500 or $1,000, they remain in custody. Is that a good assessment?
A high bond is a relative term because it depends on what kind of resources you have. If I don't have any money, if you set my bond at $10, I'm not going to be able to get out of jail. If you set my bond at $3 million and I'm a billionaire, $3 million doesn't, cause me any kind of stress at all, and I can get out. It doesn't speak to whether or not I'm guilty or not guilty, whether I'm a flight risk or I'm not. There is no nexus between a monetary figure and the somebody showing up for court or committing a new offense.
Can I add one thing just for clarification though? When a person is arrested, if they are, the schedule only applies for misdemeanor offenses, non-violent offenses. So if a person is arrested and they are charged with a felony offense, there is no schedule. They will see a judge within that municipality in which they were arrested. Now Cleveland Municipal Court has court on Saturdays, unlike other courts in this county, because of the requirement that you're supposed to be seen within a 48-hour time period if you are arrested. But if it is a felony offense, you will have to see a judge. Now, sometimes, and that has been reduced, that you may get a phone call as a judge and the judge may order a bond, but that practice has been, at least within a short time period, I've only been gone a year, that attorneys weren't calling for bonds like they used to when I first started. So the person ends up waiting in jail until they see a judge that next day. Mm-hmm. And then the bond is ordered based on the information that's provided.
And really, when we did bond reform in the Cleveland Municipal Court, we actually established a process where beyond Saturdays, judges will actually come down to the courthouse on Sundays and review cases that had been brought by the police and make a determination as to bonds when it was appropriate.
Speaking of reform in the Cleveland Municipal Court, I know that you were very instrumental in starting that process. What steps did you take to reform the Cleveland Municipal Court? I know that you were on a task force, and I know that there was research done. Explain to our audience, where did you look at, and how does it different than what Ohio has currently?
We did a number of different things. The first thing that we did just had to do with taking a look at the bail schedule that we had for misdemeanors. The bail schedule was arbitrary. We'd say if you were charged with a first-degree misdemeanor that involved some form of traffic offense, your bond would be set at $1,000. If it was an offense that was a theft offense, it might be $2,000. There's no nexus between those numbers and those offenses. So we reformed that so that if you weren't charged with some kind of a criminal offense someplace else, and if the offense that you were charged with didn't involve violence, then every offense in the Cleveland Municipal Court was eligible to have you get a personal bond pending, your next appearance in court. We also brought in a risk assessment. Instead of using how much money you had, we started to make decisions about bond based upon what kind of a risk you pose to the community and to others, as one of the things that we were looking at when we decided what would be an appropriate bond for you to get. And so a lot of people were then allowed to get either lower bonds or get personal bonds because of those assessments that we did.
Okay. Now, did you look at other jurisdictions such as, for instance, New York or DC?
I actually made a trip to the District of Columbia, which has the most well-developed pretrial services agency in the country. Of course, they're hooked up with the federal government, and so they have a $45 million a year budget. But they pointed out to us quite quickly that there were a lot of things that we could do that didn't require us to have a whole lot of money. And one of the things that we could do was to reform that bail schedule. And then when we came back and we reformed the bail schedule, folks like Judge Pat Carroll in Lakewood and some others around the state of Ohio took a look at what we were doing, and they made similar reforms as it related to that. And the Chief Justice did a thorough dive into, what was required. And based upon what she found, they started to do bail reform across the state of Ohio as it related to bail schedules. And now every jurisdiction within any given county is supposed to homogenize its bail schedule so you don't have this patchwork of situations depending on where you get stopped.
Okay, Judge Cassandra Collier-Jones, on the county level for Common Pleas Court.
You said Cassandra Collier-Jones. Okay, I think you meant
Both of
Williams.
us.
All right, it's all good.
Williams,
All right.
my bad.
No problem.
Judge Cassandra Collier-Williams, in the county system, we've heard of what our former administrative judge and now our current administrative judge have utilized the FAD docket, the first appearance docket. And from what I understand, that's a system where instead of people prolonged in their detention from municipal court once they're charged with a felony and then bound over to the common pleas court, and you're at that time, you're supposed to be scheduled to have an attorney if you can't afford one. But my question goes more to this. In that system, in that new reform system that the county has initiated since 2018, I believe it's been, are you seeing arguments? What do you expect from the prosecutor versus what you expect from the defense attorney in order to aid you in making that decision to have a monetary bond or maybe perhaps a non-monetary bond? What are you expecting from the litigants?
Well, let me just say this. The first appearance docket is it's almost non-existent. I mean, it's not as prevalent as you may think. Now, a few years ago, we actually, if you were in the arraignment room, you had two dockets. You would come in the morning for the arraignment, you come in the afternoon for the first appearances. Now you don't do that. Now they sort of intersperse them. On the first appearance, we give we assign a counsel if they need counsel. We give a bond, but most of those cases now go straight to the grand jury. So all you do, you say, okay, the bond is this amount of money. Here's counsel for you. This matter is going to the grand jury. It's very rare now that it's set where, okay, it used to be they would get a pretrial hearing. They would a pre-indictment hearing where they could come in, you try to resolve things early. We're not seeing a lot of that anymore. And I don't know whether the emphasis is gone from that, but I can tell you we don't see a lot of it anymore. And just to kind of piggyback on some of the things that were already said, one of the problems with setting bail is that oftentimes bail is set at an amount because that's just what is done. Okay, so if it's a murder case in Cuyahoga County, most of the time it's going to be $1 million, and that's just what it is. There is no rhyme, there's no reason, there's no inquiry. The prosecutor is going to ask for it, and most times the judges are going to say the $1 million bond, and they're done with it. Every now and then, you get cases where the judges will say, wait a minute, I'm not doing that. I'm going to give a lower bond, or I'm going to give a personal bond in this situation. But a lot of times they don't, because of fear of the public, it may hit the paper, fear that for some reason that particular defendant may go out and do something else, and you don't want to be on the front page again. Fear of the ballot box. We're elected every 6 years, so you have that fear that some of the judges have, where they're like, okay, I'm not going to rock the boat. I don't want the prosecutors mad at us. I don't want the defense bar mad, that kind of thing. But so it takes, I always tell people, it takes a lot of courage to be a judge, and to be a good judge takes a lot of courage, because you can't be concerned about what the public or what the media is going to say and do. You've got to do your best to do the right thing. And to give you an example of that, in Hamilton County, the prosecutor has gone to Facebook and putting the judges on blast whenever the judges lower bonds or give people personal bonds that they don't think they should. And those judges are, they're feeling that heat on them, because the prosecutor is calling them out all the time. So, I mean, that is a real consideration when you're looking at bond, and it shouldn't be. It shouldn't be. But again, it takes courage to sit there and look at the family who's there begging. And this doesn't have to be a murder case. It could be just a burglary. It could be a domestic violence. It could be robbery of some sort. And they're sitting there saying, oh, lock them up. Don't give them any bond. Lock them up. Your Honor, please lock them up. And you got to be able to look at them and say, they deserve, you don't have to be locked. I got to give them a bond that they can afford to get out. So that's just.
I know that Ohio currently provides, for the last 20 years at least, a statute that allows for preventative detention. If the crimes are so serious and you can meet that clear and convincing evidence standard. Judge Jones, can you walk us through a scenario? Have you had one of those detention hearings where you found by clear and convincing evidence that this person must be held? And looking at all the factors under Criminal Rule 46 concerning the weight of the evidence, the defendants confirming the defendant's identity, whether a gun or weapon was used in the offense, those sort of factors. Have you had to go through that mental analysis in determining whether a person should be held pursuant to the statute?
So interestingly enough, I have set several of these hearings, but because this is a new process that really isn't happening much in the court, I mean, change is slow. But what I do is I sit the attorneys down and I explain to them that the expectation at this pretrial detention hearing is that we're going to go through this analysis. I'm going to hear evidence. You can put on witnesses. Both the state can put on witnesses, the defense can put on witnesses, and the evidence that they're going to be putting on is related to those factors. Whether the person's identity is, 100%, like was this a stranger situation where their identity is in question, or family member where we know they knew exactly the identity of the defendant. What is the weight of the evidence? Because those are the factors I have to weigh in making a determination about whether this person is a danger to the public or to themselves. And I have to look at all of that. So when I've sat attorneys down and explained to them the expectation, and I go through Criminal Rule 46 with them, as well as the statute of how that procedure is going to go, they end up working out some sort of agreement a lot of the times because they both have some risk there. The state sometimes doesn't want to put their trial strategy out. There's a question about whether the cross-examination of the witnesses is going to impact the defense strategy or the state strategy, and they don't want to put that out there so early on in the case when discovery hasn't even happened yet. So, depending on the case, it may not make sense to have that pretrial detention hearing. So it's not cut and dry. And part of it is trial strategy when attorneys are deciding whether they're going to file that motion asking the court to have that pretrial detention hearing. So all of the ones that I've set ended up resolving in some way. I've got one coming up, and that's a pro se defendant. So I'm going to follow that pro se defendant is going to have the same rules as an attorney, and we're going to have that hearing. He requested it and he'll get it. So the short answer is haven't had one yet, but have said a lot of them.
Okay, thank you. Judge Groves, one of the major controversies that's going on now is a decision that was decided by our Supreme Court concerning bail. And I believe that for those of us in this business, we know that that has had a huge ramifications on new legislation being proposed. Can you take us through McGuffey versus DuBose that was decided in January of this year, and how that impacts our constituency, and how whether or not there's going to be a proposed amendment that our voters must vote on in November? Take us through DuBose, if you would.
Okay, just, and I'm going to try to be as quick as possible in the interest of time. And just to clarify what the court does, the court looks at the facts and the law, and then they make a decision. So in DuBose, the defendant was arrested for murder, aggravated robbery, and aggravated burglary. He was given a $1.5 million bond. A couple of hearings were had. 8 months later, he's still in jail. It got reduced from $500,000. The family was not notified. When the family was notified, it went back up to $1.5 million. And then after 8 months, they went to the Court of Appeals and filed a writ of habeas corpus, which is a motion when there's the belief that a person is being held unlawfully. And so after the writ of habeas corpus was granted, petition was granted, the bond was reduced to $500,000. Then at that time, the prosecutor then appealed, and that's how the case ended up at the Supreme Court. But one of the things that did not happen in that case is that there was not a request from the prosecutor to have the defendant held without bond. And so you can't use the cash bond as a subterfuge to no bond, because you backdoor no bond when you do a $1.5 million bond. More than likely that person cannot make that bond. And that's what the Supreme Court did. The Supreme Court honored the law and honored the Constitution. The Constitution says you can't have excessive bail. So if you have a $1.5 million bail and you can't make it, that's excessive. Now, if the thought is, and the prosecutor wished to not have the person held, because the grandmother said, I don't feel safe if he is out on the street and I don't want a bond. And so certainly victims, rightfully so, will feel that. But as a court and the law, we have to separate that and then look at, okay, this person is in jail. They're presumed innocent, but there are some things that you can look at, and that hearing did not happen. So the Supreme Court just basically enforced what the Constitution says, you're not to have excessive bail. Looked at Criminal Rule 48. There is a process that should be followed in setting bail. Bail is not to ensure the safety. It's one of the things you can look at as the nature of the offense. But if you impose a bail that is greater than that person's ability to post the bail, then you have violated the criminal rule, you violated the Constitution, and you violated our high revised code. And that's what the Supreme Court did, was to bring the awareness. There are the tools in the toolbox that could have been utilized, and they weren't. And so it really was just to recheck. Now, because of this, there's all kind of knee-jerk reaction that is now afoot, that will probably put the issue on the ballot in terms of having a constitutional amendment. But again, money is not, you can't buy your freedom with money on these cases, because many people can't afford it. And that's what DuBose says. DuBose says to follow the law, have a bond that a person that is not excessive, and if their person is a risk, you can have a hearing. And then there's no money. Money is not even exchanged because a person remains in jail. I did see a question in the chat, how long can a person remain in jail? We have a constitutional right to have a speedy trial. So you're not supposed to be there for a long time, but sometimes that for purposes of preparation, that speedy trial gets waived and the person can sit in jail for an extended period of time, a couple of years even, before the case is resolved.
If I just may interject briefly, Judge Adrian, what are some of these non-monetary conditions that a judge has the authority to place upon a person charged with a crime? and knowing that they're presumed innocent, they haven't been convicted of any crime yet, and this is still before their trial or before they resolve their case. What are some of those non-monetary conditions that a judge has to place on a person to assure that they will appear in court and assure the safety of the public?
Before I get to that, let me just add one thing to what Judge Grove said. You know, the prosecution has an obligation if they think that somebody is so dangerous that they can't be released under any condition. Before we even get to whether or not there is a monetary amount that they think would assure, you have to establish, first of all, that they're that dangerous. And in DuBose, this is one of the things that made DuBose a special case. This fellow was charged with murder, amongst other things, but when it came to reducing his bond from $1.5 million to $500,000, the rationale for going back up to $1.5 million was that the grandmother of the victim indicated that she was so afraid that, you know, of that person being on the street. There was no hearing had to establish, you know, what the basis of that fear was. That was a responsibility the prosecution had to show why that was a logical and reasonable fear that she had, because there was no contact between her and these people before. She didn't even know who they were. Okay, so that's one. And to answer your question, you know, there are a number of other things that you can use. It may be that you require somebody to have electronic monitoring, that is, put a bracelet on it that lets you know where they are geographically. There might be a requirement that they undergo drug testing and drug treatment. You might require that they have other kind of counseling in the interim period. There are any number of things that courts can put in place in order to assure that the persons show up on a regular occasion to meet with court staff, or that they be put into a position where they have to call, so the court will always know where they are. There are those things that are available that a court can assess to determine whether or not they think that they will allow them to let somebody be out at liberty. And those are the things that you have to consider before you ever get to cash bond. And then when you get to cash bond, you know, you're not supposed to put on any person any more money as a requirement than what they can reasonably be expected after you take into consideration their living expenses and everything else that they would need to survive, to be able to make. And if it's more than, I think it's a third of their ongoing expenses that the bond would cause them to have to put up, then it becomes excessive.
I'm just going to throw this out to the panel, and I know we only have a few minutes left, but what are some of the real collateral effects of being held pre-trial or waiting for your day in court that people suffer and their families may suffer? And anyone can jump in on this.
Right off the bat, their livelihood. If they have children, their children are in jeopardy of being taken into custody. I just want to add just quickly, and then everyone else can chime in. DC, 97% of the people arrested in the District of Columbia are released without paying a penny. They may be subject to other conditions, and that has been going on for the last 50+ years. And so part of it is that now is a culture where that is what is accepted. I recall asking a question, well, what if a person goes out and commits a crime? That has not deterred this practice for over 50 years of the tools and the resources that they have. That only 3% of the people arrested have been deemed unsafe, creating a safety factor.
And that's regardless of what they were charged with.
Regardless. So if you have a murder, and in DuBose had no criminal record. So he didn't have a history of not showing to court because he was never required to go to court. He did not have any felony convictions. And so he had pretty much a clean record. And those are the things too that you look into in what the bail should be.
Another thing that we just don't talk about it enough we always talk about mental health crisis and diverting people from coming into the jail. But when someone is charged with a very serious crime, they are going to be booked into the jail. And the time period between being booked into the jail and their case making its way through the system, that person can go from a mental health crisis to full-on psychosis. And then there's, the time period it takes to stabilize them so that they are able to even participate in their own defense. In addition to the danger to the people in the jail and the correction officers working there, it doesn't save any money, and it puts everybody at risk.
As judges, have you all seen a correlation between being held in jail for weeks, months, sometimes even years we've seen here in Cuyahoga County? Have you seen a correlation between that and being incarcerated or sentenced to prison?
There's a lot of research on this, Russ, and the research suggests, just on the pre-trial end of things, that being incarcerated for as little as 3 days causes people to start to suffer what they refer to as cumulative disadvantages. And a cumulative disadvantage is when you have something bad that happens that then causes a cascade of other bad things to happen to you. People who spend an extended period of time in jail are more likely to be found guilty of an offense, are more likely to be sentenced to prison, are more likely, even if they are allowed to be released from jail, if they've spent the more time they spend in jail pre-trial, when they are released to jail, they're more likely to commit a new offense. There is very little good that happens for people who get put into jail. And obviously there are some people who we have to be concerned about because they are dangerous people. But for virtually everybody else, we have ways and means to monitor that behavior while they are at liberty that allows them to be, if not productive, at least not destructive in the community while we're waiting for us to resolve their case in the courts.
Now, I see that our time has expired, but I do want to, if we have a few minutes, because we started a little late, Jasmine, do we have a time to answer some questions from our chat room?
Yep, we sure do.
I can start on a quick one on Mayor Holbert's question. If the crime is horrendous, then certainly they would be held without bond. And you have to go through that process. You don't do a $10 million bond. You just say, you have a hearing and you make the determination that the person creates a substantial risk to the community. And therefore, given the evidence, now certainly, you got the gun in the hand, you got all this evidence clear and convincing, then they should not be released. And I think that's where the education piece comes in, to let the community know also how this thought process is supposed to work.
I see another question that talks about mental health. Mental health is one of the biggest problems that we have in trying to deal with criminal justice issues, because the amount of resources that the community has made available to address mental health is abysmal. And so a lot of people, 40% of the people who were held in the Cleveland Municipal Court had concurrent mental health problems. So when you look at that, you recognize that we need to do more in order to try to address that on the front end.
And that is one of the things that Criminal Rule 46, one of the changes to it is that it allows us at that, that pre-trial stage to divert someone to an inpatient facility. But it's we have to get a process in place to make that happen at arraignment, I think.
And that's part of the reform. That's part of the reform effort, right?
Mm-hmm.
Thank you. Judge Jones, would you mind answering the question from Essence? As a defendant determined to be a flight risk, can you talk about what are some of the risks you think about when determining setting bond? Like if they haven't come before, if they've been FTA, what kind of weight do you place if they've, say, cut off a band before? How does that affect your decision?
So I do use history, and that is the first thing I go to once I've made a determination that the person is eligible for bond. They can be in the community safely. Then I look at how do I ensure that this person comes back to court? So that is where I'm going to maybe set a bond amount that it's not going to be personal bond for someone who has a history of not reporting. There may be a bond. It still has to be proportional based on their income, but I have to ask those questions about, if they work, that kind of thing. And I look at, if someone has a job, what are the measures I can put in place to ensure that they keep that job while this whole process is going on? Because you lose your job, you lose your housing, you could lose your children. The long-term impact, it takes years to recover from something like that. And so even if someone in the past, if they have cut off an ankle bracelet, they are going to have to pay for that ankle bracelet, and I may have to put some other measure in place. But if they've got a job and they're going to that job, they may have to report more often. I may make that person come to court for pretrials, where typically I don't require the defendant to appear at every pretrial. Someone who has a history of not reporting to court, I would make them show up and see them every time. So those are the kinds of things I look at and that I do to ensure that someone who's got a history of not showing up shows up.
One thing I just want to jump in and just ask our panelists, and I know we got to transform to our next panel, is during COVID, we saw massive reductions in our jail here in Cuyahoga County. And I believe if my memory serves me correctly, Administrative Judge Brendan Sheehan quoted a week or so ago at the 8th District Judicial Conference that we went from somewhere around 2,200 inmates in our jail down to 900 at one point in time during the year 2020 and early parts of 2021. Is that something that we can maintain? Because from what I'm understanding, the numbers are back up to somewhere around 1,600. So was that a sense of bail reform? What did we do? I guess this may be more appropriate for the next panel. What did we do collaboratively to make sure that the numbers were down during the pandemic that we cannot do moving forward? So Judge Adrian, I'll leave that with you. Leave that in your able hands to address that, perhaps with the next panel, and I will not delay that process.
Thank you, and we'll pick it up.
All right.
So, thank you for allowing me to participate in the first panel. And now as we turn to the second panel, our second panel is constructed of individuals who are members of the practitioner cadre, and Jasmine's going to introduce them.
So our second panels consists of Attorney Carrie Howard. Carrie D. Howard is the current Chief Director of Cleveland's Department of Public Safety. A career prosecutor, Director Howard has served as an assistant prosecutor for the city of Cleveland and Cuyahoga County. He has also served as former Chief Prosecutor for the city of Cleveland and former Assistant United States Attorney for the Northern District of Ohio. Our next panelist is Attorney Aquila Jordan. Aquila has spent her entire professional career working as a public servant. During her time attending Cleveland Marshall College of Law, she served as a law clerk in the Cleveland Municipal Court. While at the City of Cleveland Prosecutor's Office, Aquila's passion for criminal litigation and appellate oral arguments increased. She joined the Cuyahoga County Prosecutor's Office in 2013, being promoted to the Major Trial Unit in 2016. From 2016 to 2020, Aquila prosecuted some of the most complex cases in Cuyahoga County, with much of her time focused on child victims. In July of 2020, Aquila returned to the City of Cleveland as Chief Assistant Prosecutor, where she is excited to continue to work towards equity in the criminal justice system while ensuring the safety of the communities she serves. Our next panelist, Attorney Diane P. Russell. Diane currently serves as Chief of the Criminal Division of the Cuyahoga County Prosecutor's Office. As Criminal Chief, Ms. Russell supervises the General Felony Unit, Major Trial Unit, Major Drug Offender Unit, Grand Jury Unit, Crime Strategies Unit, ICAC Unit, which stands for Internet Crimes Against Children, the Intake Unit, the Investigative Unit, and is the Director of Extraditions and the Diversion Program. Ms. Russell began her commitment to public service with the Cuyahoga County Prosecutor's Office in 2003. She worked her way through the ranks, beginning as a litigator for parents' rights to receive financial support for the care of their children, to representing the state of Ohio against those that committed violent crimes against the citizens of this county. Ms. Russell was born and raised in this community. She graduated from Cleveland State University and Case Western Reserve University, respectively. For the last 18 years, her journey and dedication to public service guides her goal of seeking justice and fairness in all matters. Our final panelist, Attorney Cullen Sweeney. Cullen Sweeney is the Chief Public Defender for Cuyahoga County. Cullen has devoted his professional career to advocacy on behalf of poor and marginalized individuals and communities. After graduating college at Miami University of Ohio, Cullen spent 4 years living in Anchorage, Alaska, working as an AmeriCorps Vista volunteer with Native Alaskan communities, and served as Executive Director of Habitat for Humanity Anchorage. In 1999, Cullen returned to school at the University of Wisconsin to pursue a joint degree program in law and public policy. Cullen began his career with the Cuyahoga County Public Defender in its appellate division in 2005, after clerking for 2 years with a federal judge. At the Public Defender's Office, Cullen has handled hundreds of appeals, authored several amicus briefs in the Ohio Supreme Court, and has personally argued more than a dozen cases before the Ohio Supreme Court. He's also handled numerous cases in the Cuyahoga County Court of Common Pleas and litigated habeas corpus petitions in federal court. In 2017, Cullen became both the supervisor of the appellate division and the deputy chief public defender. He served in that capacity until his appointment in 2021 as chief public defender. Back to you, Judge Adrian.
Thank you, Attorney Jackson. So let's jump right in and pick up where Russ left off. In early 2020, because of the pandemic, there was this push, this imperative to reduce the jail population because of the dangers of having all those people in such close proximity. All of the different agencies that had some piece of that action came together to review what measures they could take to reduce the jail population overall and to get as many people as possible out of the county jail. Can each of you or any of you speak to why it is that we would be able to reduce the population from close to 2,200 people down to 900 people, only to see it rise to its current level of about 1,766 people? Is there any explanation for why numbers have gone back up? And is there anything that we can do, especially as it relates to the pretrial population, that would cause those numbers to go back down? Anybody want to speak to it?
Hey, Judge, if I may, this is Kerry Howard.
Sure, Kerry.
So when COVID came on, the city of Cleveland, in collaboration with the Cleveland Municipal Court and the city prosecutor, we looked at how and why we conduct arrests. Our current population in the county jail for the city of Cleveland is about 130 people. So we changed on what criteria we arresting for violent crimes and for some of the other petty offenses or less serious offenses. We've issued citations or had the officers go to the prosecutor's office to seek a summons and to summons people to court. So Cleveland has changed the way that we decide who to arrest, when to arrest, and incorporating the diversion center into that we've been able to keep our numbers low. And our goal is not to go back to what pre-arrest arrest levels may have looked like.
Diane, I know that at the 8th District Judicial Conference that Judge Brendan Sheehan indicated that the population that's now being held in the county jail has a much different composition than the population that was being held in the county jail prior to COVID. Do you want to speak to that?
Yes, Judge Adrian. Right now, we have jail review meetings every Monday, which we had it today. It's Tuesday. Yesterday was a holiday, and most of the people being held now in the county jail are unclassified, which are mostly murders, felony 1s, 2s, and some 3s. The low levels, 4s and 5s, are only about 8% of the jail population now, whereas before, when COVID first started, those numbers were much higher. 3s, 4s, and 5s were much higher. Those people couldn't pay their bonds before COVID struck, and they were let out. And that was hundreds and hundreds of defendants, because you saw how the numbers dropped. Russ just mentioned it. So that's the different makeup now. Most of the folks that are in the county jail now are on the high level offenses.
I know that you've been very active recently in taking a look at the number of people who get brought into the system, and that some changes have come to pass with the advent of the new administration for the city of Cleveland. Would you like to speak to that?
Thank you, Your Honor. Absolutely. You know, the Bibb administration has been very aggressive in supporting the Cleveland Municipal Court's initial goal to reduce those who are incarcerated. And we've done that through a couple things, right? We reevaluated how we dealt with the diversion center, really trying to push more people there in order to deal with their mental health crisis, in addition to continuing the use of St. Vincent Charity Hospital, which Cleveland Police had already been doing. As Director Howard said, Cleveland Division of Police changed the way in which they began arresting people. So we were focused more so on the violent offenses. And then we became more sort of team players with the Cleveland Municipal Court and saying, you know, this is the bond schedule that the judges have proposed. We're completely in support of that, because we want our time and attention focused on the more serious offenders as opposed to these lower level offenses. We understand the collateral consequences of pretrial bail and pretrial detention. And so we really took a hard look at what was in the best interest of the community, understanding that Marcy's Law is still at play. Victims have a right to be heard, and it's important to remember the victims in this conversation. But really, the Bibb administration has been very aggressive in saying, this is how we're moving forward, and this is how we better serve our community.
Colin, let me turn to you just really quickly. You know, there is a pretrial detention statute that's in place in Ohio that is available to courts to use. However, that pretrial detention statute doesn't necessarily reach all of what we might consider to be violent offenders. Can you talk about, you know, what the reality is in Cuyahoga County as it relates to the use of the pretrial detention statute?
Yes, thank you, Your Honor. Yeah, I would say that it's almost non-existent in terms of its use. I observed our office had exactly one pretrial detention statute since DuBose has come out, and I was never involved with one before that. And I think that speaks to a little bit of what Judge Groves was referring to as a subterfuge, in the sense that there has been no need to rely on the pretrial detention statute, because for so many years, bonds were just set in serious cases at an amount the defendant could not make in general. And so that has been an issue. And in response to your initial part of that question was, well, the pretrial detention statute doesn't extend to all felony offenses of violence. That's part of the pending House bill legislation, bond reform legislation that would reduce the amount of monetary bond, but it would increase the number of offenses that could be subject to pretrial detention. So that's the give and take of some of the pending legislation.
So what is the problem? Because it seems to me in large measure that the constitutional amendment is a solution looking for a problem. And I'm just wondering whether or not that constitutional amendment and the proposed statutory fixes to bail are going to be at cross purposes, or whether they'll be capable of working together. What's your thought about that?
Well, I think that, so the constitutional amendment, for those not familiar with it, it's an explicit rebuke of the DuBose decision, in the sense that it says that public safety shall be considered when setting the financial conditions of bond. It's not at all clear that that would survive an Eighth Amendment challenge under the US Constitution, but that is why it was enacted. And I think, or is being proposed for adding to the ballot. And so that is working in a way at cross purposes as some of the bail reform legislation, which, as you mentioned, Judge Adrian, is intended to require, number one, have a presumption of release on personal recognizance. But to the extent that you are going to set a bail, it caps the amount of your bail at 25% of your annual income minus basically debt. So for a lot of individuals, that number is very small. You know, a lot of people live on the margins. And so the amount, if you decide the person can be released safely into the community, the amount of bail under that statute would be low, whereas the Constitution would be saying you should be looking at a high amount if it's a serious case. So there is a tension between the two.
Diane, from the position of the county prosecutor's office, what was the reaction to the DuBose decision?
Well, we do have a new bond policy in place based on the decision from DuBose that became effective March 2nd. So we do have a new policy, and it basically follows DuBose. I will say this though, we were very confused about the court. It seemed the court totally ignored the fact that I won't say he ran to Las Vegas in DuBose, but he went to Las Vegas, and when confronted, he presented a fake ID and presented himself as the person on the fake ID. So that was concerning to us in our office. It pretty much denoted flight from what had happened in Cleveland. So we were concerned about that, but we have respected the court's decision. And like I said, we have a new policy in place where we are not asking for excessive bond, except of course in murder cases. I can't say that we won't ask for $1 million in a murder case, because that is most likely going to happen. But on other cases, we are asking more for like GPS monitoring or court supervised release. As a matter of fact, the sheriff has increased the amount of monitors they have by, I believe it's about 645 now. And at the last meeting, there were only about 20 available for defendants coming through their bond hearings. So we are using those, and we are using other means instead of asking for excessive amounts of money.
So with regard to the high bonds that are requested in murder cases, is it fair to say that those high bonds are requested primarily because of the nature of the offense?
Typically, it's the nature of the offense. It may be the defendant's criminal history. It may be, or the nature of the offense itself. Sometimes, though, honestly, some people murder and they have no record whatsoever. But high bonds are requested in murder cases, and typically every murder case.
And is the purpose of requesting those kinds of bonds to accomplish pretrial detention?
It is to keep the community safe, honestly. We ask for high bonds to keep the community safe, to keep the defendant detained because he's committed a murder. It doesn't get any worse than that. So that is typically why it is requested.
At least that's the accusation, right?
Right.
Okay.
That's the accusation, correct.
Okay. Carrie, what's the thought process with regard to the city prosecutor, because you served in that role for a while before you moved over to the safety director, and what's the thought process in the police department as it relates to the DuBose decision, and have any changes been required in the way that you look at bringing people into the system based upon DuBose?
So, Judge, what the change that we've made in light of DuBose is having our officers are required to give the prosecutor more information when they present the charges to the prosecutor, and to make an argument for detention. In the past, the police officers would stamp their probable cause sheets with the high bond request for violent crimes, and of course, police officers want the violent offenders to stay locked up. And so the only change that we've made is the communication that we give to the prosecutors, so that the prosecutors can have the tools that they need to make the argument for detention in the most serious offenses.
Okay, and Aquila, with regard to your office, when those cases come before you, what kinds of things are you demanding from the police in order to feel comfortable in making a request for a significant or substantial cash or monetary bond?
Yeah, so our Cleveland Police Department is doing a lot more work up front, and they're doing it under the radar gun, right? Because in Cleveland, you still have 36 hours from the time of arrest to make a charging decision, right? That was one of the things that was previously put into place in Cleveland. That's really good, right? Because we want to make sure that when we're arresting someone, we make that charging decision. But it means our detectives are having to do their investigations much quicker. They're going to have to bring us the strength of their evidence, right? We're looking at all those criminal rule 46 factors. What is the strength of your evidence? Can you confirm ID? What is the credibility of your witnesses? What supporting evidence do you have? Is there video? Have you obtained it? We want to see the video before we make that charging decision. And so these are all things that our detectives are now bringing down, and it's really increasing the type of conversations we're having so that we're more confident in our charging decisions, because that's what you want as a prosecutor. You want to know that when we refer a case up to the county prosecutor's office, we're referring a strong case that will go beyond probable cause, right? We want to know that we can help that county prosecutor reach beyond a reasonable doubt before we charge someone and impact their lives in a very meaningful way.
Cullen, what are you seeing?
I guess as far as change practices, I think that judges, one of the things that I see is many of the judges on the bench, as opposed to just accepting recommendations from the bond commissioner, which I think was more of the historical practice, are now more seriously considering bond reduction arguments and more frequently utilizing the non-financial conditions of release like GPS and things of that nature. And I agree with Ms. Russell that the low-level individuals accused of low-level offenses are generally getting personal bonds and are being released. We tend to have probably more arguments back and forth over people charged with F2s and F1s and what should be the appropriate conditions of release and appropriate bail in those cases than on the lower level cases.
Would you guys say that we all are all on the same page when we even talk about the language and the definition of what constitutes bail, what constitutes bond? And if not, where do you think that we might be at cross purposes?
Go ahead, Diane.
Sorry, Cullen. I feel that most of us are probably pretty much on the same page. We know that bail means we're trying to ensure that the defendant will appear So I think that we're pretty much on the same page, at least I feel like we are, on what it means for us. Now, how we're going about that, now that DuBose is in play, has changed greatly. But I think everyone is on the same page when we believe that there needs to be bail reform.
The one thing I would say is that, you know, the Supreme Court decided a case in 1951, Stack versus Boyle, which basically said that the purpose of bail is to ensure the person's appearance at court, and any amount in excess of that is excessive bail. And I do think for many, many years, we have seen this growth in the pretrial detention population because there has been a greater reliance on financial conditions of release. Actually, the pretrial detention population since 1970 has grown by over 430%, from around 80,000 in 1970 to around 500,000 today. And a big part of that isn't because necessarily there's more serious crimes being committed. In fact, some of the statistics show over the last few years, number of felony arrests have actually decreased. But it's because of the reliance on the financial aspect of bail. And really, bail is both the financial conditions and the non-financial conditions. And I think the purpose of the DuBose decision is to reset the way we look at bail and say financial conditions go to showing up in court, non-financial conditions go to public safety, or pretrial detention goes to public safety. And I think we're still in an adjustment phase, and that'll be muddied by the constitutional amendment that is passed. So
I know that a lot of judges, at least when I was on the bench, and we were talking about pretrial detention, and we were talking about money bonds, and we were talking about alternatives to money bonds. There were a lot of judges, especially out in the municipal court, in the spots where the resources were not as heavy as they were in the Cleveland Municipal Court. They didn't have as much to work with. The local jurisdictions really didn't give them the same kind of latitude that they gave us with regard to money to throw at these problems. There were a number of jurisdictions that would say to me when I would say, hey, this is what the Constitution requires. You really shouldn't be putting these heavy bonds on folks. You got to come up with another way. And they would say to me, okay, I hear you. I understand what you're saying. But if we're not going to use money as the thing to secure the safety of the community, then what do you suggest that we use instead? And so I'm going to ask the same question of you guys. I've got three prosecutors ganging up on one defender, but I'm interested to hear what each of you have to say about how we can make sure that the community apprehends that it is safe if, in fact, we move in a direction that would suggest that we're going to look at something else other than money as the thing that we're going to put in place when people are looking at being released from pretrial detention. Anybody want to jump in?
Judge, I'll start. I'm not in the prosecutor's world anymore, so I'll start and then let the other prosecutors chime in. But I'm not a fan of a money bail system. I think it's classist. I think it has racist elements to it. I think it raises concerns that those who have aren't able to get out. I think that we should look at the factors that go into detention that are considered both by the federal courts and by the Ohio Revised Code, and apply those factors to a consideration of whether or not someone gets released. And I think that they can be applied to someone who commits murder or rape or some of the most heinous crimes. because we also have witnesses and families of victims and families of witnesses to worry about. So I think that can be extended. I think that the money bail system is an antiquated system.
And just chiming in on what Director Howard said. Oh, go ahead, Diane.
No, go ahead, Quayla.
Just chiming on what Director Howard said, you know, I hate to brag on Cleveland again, but I'm going to brag on Cleveland, right? Cleveland's jail population right now is at about 130 for individuals who have solely Cleveland municipal court cases, right? So we're talking a fraction of what's in the jail. And that's because we have been more proactive. You know, our judges in Cleveland Municipal Court are phenomenal. And they've been very intentional about GPS, about setting up a restricted zone from the victim, about making sure there's a protection order in place, about making sure there's pretrial services that is funded by the community, right? Our citizens fund our pretrial services department to give those mental health and drug dependency services to defendants before they come before the court. Those are the things we need to focus on, because we have to remember, bail is about ensuring the defendant appears for court. That's what we're really trying to get at the heart of here. And so I think when we begin to really unpack it, I think, you know, we have to give credit to something I heard City Councilwoman Stephanie House say in one of the recent hearings that she was doing before the Safety Committee. She said, what causes an offender to commit this offense? And that was what she was really trying to ask the panel. And I think that's something we have to look at when we're considering these bail requests, right? What is it that's causing the offender to commit these offenses? And can we safely secure the defendant from continuing that action while this court case is going? Our pretrial services department in Cleveland really looks at that. They begin to unpack those issues about why the offender is offending, get them the services to ensure they'll be at court. And that's what bail reform really should be focused on.
Diane?
I agree with you, Aquila, wholeheartedly. I think pretrial services needs to be increased dramatically for the county. We need risk assessments done. We need drug and alcohol assessments done. We need financial assessments done. Does this person have a job? How can we keep the victim or the community safe if it's a violent crime? The GPS monitoring seems to be working well. But again, like I just told you, we have over 600 units and being used now and only about 20 or so available. So that's a big thing. Have in-person reporting done. So there are a lot of ways to ensure that a defendant is compliant with all of the restrictions that may be placed upon him while he's on bail without making him pay financially. There are ways to do that. We're seeing it more, but we could also see it more often.
I think one thing that we could definitely improve upon, and this is really an administrative challenge that is resolvable, and that is that there needs to be a better integration of pretrial services for felony cases as they are arising in the municipal courts. So if there's one thing I've heard Judge Michael Nelson say maybe 100 times, is how frustrated he is about the fact that if he's hearing a felony case and setting a bond in a felony case, they can't get a GPS on the individual right away because it's going to be a felony case. So they're not going to be subject to Cleveland pretrial services. And I think that really does delay. And Judge Adrian mentioned how 3 days in custody makes a difference. Improving that coordination, and unlike Cleveland, who deserves a lot of credit for their pretrial services, a lot of the suburban municipalities do not have any real pretrial services at all. And so if there was something that could be done to improve the coordination of those services throughout the county so everyone has the same opportunity, I think that could go a long way to helping as well.
I know that when I left the bench, I'd had a number of discussions with then presiding and administrative judge John Russo about the efforts that he was trying to engage in with the members of his bench to try to get them to adopt, significant pretrial services and to bring them into play in the county court. I know that the Northern Ohio Municipal Judges Association has had conversation about, how could they increase the amount of pretrial services available to the people who are arrested in their jurisdictions. But what I seem to have gleaned over time is that there hasn't been a whole lot of forward motion on either of those fronts, and that there were a number of people in the Common Pleas Court who seemed to believe that this was not something that a whole lot of time or energy should be put into. And in the municipal courts, I think that a lot of the judges just kind of had thrown their hands up because they just knew that the municipal governments were never going to give them the monies. And I thought that there was some movement, at least at one point, to get the money that was necessary to really enhance pretrial services in Cuyahoga County from the county government. Have any of you heard about any movement on any of those fronts? Because I think it's going to take resources. I really think that the folks in the county government are in the best position to kind of enforce progress with the municipal courts. But I don't know what it's going to take in the Common Pleas Court.
Judge, one of the things that is happening right now is central booking. I actually just took a tour about 3 weeks ago in the central booking area, and there will be significantly more services available when you come in through central booking. There's an area for a medical assessment, a mental health assessment. You will sit down with someone and go over, your finances, your employment, your family. So that's one thing that will bring more pretrial services to the county as central booking.
I know we were talking about central booking when I first was elected as a judge, and it just never went anyplace. So I'm glad to hear that it's finally getting up off the dime.
We're right there. We're very close. I would say probably about 6 weeks away.
That's wonderful. That's wonderful. So we've got these two directions that, pretrial could go, right? Pretrial detention, pretrial services, bail bond, all of that. It can either go towards reform or it can go towards retrenchment. And I'm interested and curious to hear from you guys. If you had a crystal ball, what do you think the likelihood is as it relates to the direction that this is really going to go in Cuyahoga County?
Judge, I am the eternal optimist, probably. And so I think this is going to collectively move us forward in the right direction, because I think we are perfectly positioned at the right time to have the right people who are reform-minded in place, who are going to make sure it goes the right way, right? And so I'm excited that we're all in this together. I'm excited that the community is engaged and right here with us to hold us accountable. And I think if we keep doing the right things and making the right decisions and focus on equity, I think we get there. And I'm excited for that.
Great.
Judge, I echo Prosecutor Jordan. I think that we're going the right direction. We have the right minds. We have the will to do it. We have the infrastructure being put in place. I think that Cleveland has been a model. I think the county is desirous of doing so. It's much better for us to get our own house in order than to have folks come and do it for us, so that we can make adjustments whenever we need to. Constitutional amendments are complicated, and they leave very little leeway for us to improve as we go along. And I think that with the people we have in place, and again, the infrastructure, we can do it.
Colin?
I think I would say that I'm maybe a little more negative by nature as a defense attorney. I don't know, but not about the people in place necessarily, but I think at a state level, I have very little confidence of any positive, not any positive, but I see a move towards retrenchment. And maybe it's because we've testified at some of these hearings and kind of seen the other side of it. And there's a lot of money in the bail bond system. The lobbyists come out in droves anytime you talk about reforming monetary bond. And so that I have a bit of a negative perspective on, but in terms of the local officials and commitment to criminal justice reform, I think it is genuine. And, I'm not sure we see eye to eye on everything, nor should we probably, but I'm hopeful that we can get our jail population back down closer to, right now it's at 1766, and I feel like we can, with work and dedication and innovation, get it much reduced. And I do think some of the high number now is a product of the fact that jury trials have been suspended at various times for almost a year. And there is a big backlog in cases, and cases weren't being resolved. And so I think we're still dealing with some of the effects of COVID. So I have local optimism and statewide pessimism, is my summary.
Cullen, I agree with you. It seems on the state level, wheels do turn very slowly. Judge Adrian, you just mentioned when you first took the bench, they were talking about central booking. And here we are many, many, many years later, and it's just coming to fruition. So, Cullen, I think we're on the same page. I don't think I'm as optimistic as Aquila. I'd like to be, but I don't think I am.
But see, it's hard for me to disagree with Diane because she's one of my former supervisors and I love her to pieces, right? But the good thing about knowing and the state sort of projecting what they're doing is it gives us a chance on the local level to get in front of it. There's nothing that stops us from talking on the local level in this criminal justice system to say, here's what the state's telegraphing they're going to do. What are the workarounds, right? We read the constitutional amendment. We know what it says. It says public safety has to be considered as a factor, right? But I think that's important, has to be considered as a factor. It doesn't say it's determining, and words matter in the law, right? So we keep having these conversations. If we keep making these moves now, I'm still holding out hope that this is gonna be amazing, you all, because we have the right team in place.
Yeah, my concern, I guess, in part is that anything that puts us in a spot where we are more dependent upon the goodwill of individual jurors puts a whole lot of people at risk. It just is a situation. It's not that I think that my colleagues, former colleagues, that is, are bad people or that they do bad things. I'm just mindful of the fact that when you are faced with a situation where you have a certain amount of fear of the optics of doing the right thing, that there's a high probability that you just might not do the right thing. And it's just like what we were talking about a little while ago with regard to the bond situation in DuBose. There was a requirement there that you establish that individual needed to be retained in jail. And they weren't saying that you couldn't do that. They were just saying that in order for you to do that, that it was necessary for you to bring forward enough information to establish for the record why it is that person should be detained. And if that's the thing that we're looking at, that is trying to make sure that whenever we're trying to strip somebody of their liberty, that we make it real plain for anybody who wants to see why, as opposed to just me as a judge having the fact that there was that person is charged with a terrible offense, and I say, okay, well, the bond in this case will be $3 million. Okay, you know, I should have to do more than that to take somebody's liberty. Doesn't mean that I can't take their liberty, but I ought to be able to do that. So, I mean, what is the difference? And I'm just going to throw this out this for everybody. What is the difference if a person doesn't have any financial resources between setting their bond at $50,000, $100,000, $1 million, or more, and just saying this, we're gonna detain this person without bond? Why can't we just move to that step instead of going through the pretense of asking for these high monetary bonds that we know people are not going to be able to make? What's the difference between doing it, and why do we go through that exercise outside of the fact that we have now acculturated the populace to expect whenever somebody is charged with a serious or a lethal event that we're going to set these unconscionable bonds? And I'd rather have somebody say, you know, look, this person is a terrible person and they've done something really terrible. And because they've done something really terrible, and we have a lot of evidence to substantiate that that is the person and that this is what they did. And that being the case, we think that they're a danger if they are out at liberty, and we're not going to give this person a bond. Why can't we just do that, you know, when it's called for, instead of going through this exercise of asking for, you know, humongous bonds?
Judge, you're absolutely right. I think that going through those steps are basically saying we're going to fix it so you can't afford to get out of jail, and I don't think that that's fair. When you can run through and you can look at the nature of the offense, you can look at the person's criminal history, you can look at the strength of the evidence against them, you can look at their history of making appearances in court, you can make the determination of just whether, you know, you're not getting a bond, you're going to be detained without a bond, and do that. If that's the type of person who is that flight risk, or carries that risk of harm to the community, then we have to. I think that's why go through those steps. I think that's the serious question that can't be answered, I don't think, fairly.
I really think the answer in many instances is that there are a whole lot of folks that just don't want to be bothered with having to go through those steps. I really do.
Yeah, I mean, Judge, I think you're exactly right. One is it's just the way it's been done is one answer to why we keep doing it this way with monetary bonds. But I do think it takes a little more time. There are steps to jump through. But in most of the cases where we're talking of where $1 million bonds are set in murder cases, et cetera, you can jump through those steps, you know, and in a way it's more transparent, and ultimately it's better for the victims too. To say to them, look, this person is going to be held in pretrial detention, not this person is going to be held unless he has a rich uncle, in which case they may be out. So I know Justice Donnelly likes to tell the story about a case where he set a bond of $1 million, and then someone came running to him to ask him to raise the bond because it looked like the guy was going to be able to post it through a bondsman. So, you know, I think it's better for everyone just to be transparent. If we think this person should be detained, let's detain them. If not, let's facilitate their release. I mean, we have some people, like I have one person we were just talking about today who has a $5,000 10% bond that they can't post. They're still in. All they need to come up with is $500. That doesn't make sense to me. You know, why we wouldn't just give that person a personal bond. So we're working on that case, but there's other examples of those. So that's the flip side to just, why don't we detain those that we perceive as dangerous?
Now we discussed, go ahead.
No, Judge, I was gonna say, honestly, I don't think anyone wants to go against a defendant's constitutional right to have bond. I don't think anybody wants to be that person that says, hold him without bond. I just don't think anybody wants to do that. So we do the song and dance of $1 million because it's a murder, instead of, like Cullen said, having a meaningful hearing and addressing all the issues.
But isn't it really a pretense? I mean, you say that nobody wants to be that person, but in
Right.
reality, they're that person. You know,
They are.
Well,
because
that's
when you say
exactly
$1
what the
million,
federal courts do.
you know, it's the same thing. So I don't know. You know, there are several states across the United States that have totally done away with the use of, you know, monetary bonds. And New Jersey is probably the first one, and is the one that's probably cited the most. New York is moving in that direction, has made significant restrictions on the use of monetary bonds. So has New Mexico. What's your thought? Well, I guess maybe the recent things that have happened here in Ohio with regard to the constitutional amendment answers the question for me. Do you ever see a point in time when Ohio might be moving in that same direction to eliminate monetary bonds if we can show that basically they're counterproductive?
I'd be very surprised at that, Your Honor.
Me too.
I feel like the state of Ohio moves very slowly,
Mm-hmm.
and being, new ideas and being aggressive and doing things differently. I just think our state moves very, very slowly. So I just don't see it happening anytime soon.
Judge, I agree with Diane there. I think
Mhm.
that it does move very slowly, and I think that what we need is progressive, leaning forward judges to start executing bail reform in their courtrooms, and to create a standard that hopefully spreads throughout the courthouse, and have changes happening proactively.
And I think sort of just piggybacking on what Director Howard said, I think something that has to be mentioned in this conversation is the importance of voting, right? We understand that we have progressive candidates up, but if we don't get the votes behind them, if we don't support the judges who are showing they are doing the hard work, right? If we don't support the prosecutors who are moving us forward in the right direction, if we don't look at these state constitutional amendments that are coming out in November and realize we have to vote on these ballot issues, then we're letting other parts of our state sort of control our destiny. We are a huge voting block here in Cuyahoga County if we can turn everyone out to vote. So it is my hope that everyone that is on this Zoom right now is reaching out to at least 10 of their friends and telling them, hey, there's this constitutional amendment on the Ohio ballot in November. I really need you to know more about it, and I need you to vote. And I need you to vote in a way that represents our population.
I know I'm going to come off sounding somewhat partisan, and I own that when I say this. But there is a very real feeling that some of the things that were put forward as far as this constitutional amendment were put forward in order to provide some talking points for the individuals who voted against the majority in DeVos. And it's going to be interesting to see whether or not those talking points now become front and center with regard to campaigns as we move forward towards the fall. Because clearly the centers in that case had a much different view of the world as it related to what the Constitution required. And the reason why I said I fear that I'm going to be painted with a partisan brush is it was hard for me as I read those dissents to understand the logic of them. And of course, every story has two sides, but I just had a hard time with it. And I don't know, you guys had an opportunity to read that case yourselves. as we're getting ready to close out, can I ask you if you had, if you were able to glean from either the majority or the dissenting decisions, some of the logic that made, even if you didn't agree with it, you concluded, I might not agree with it, but I see how they got there.
Well, I'll say that obviously I agreed with the majority, with goes without saying, but I do think that there was some, with respect to the amendments to Rule 46, with not getting overly technical, the Prosecutors Association lobbied for some changes that I think they believed built public safety into being a consideration in the monetary bond. And if you look at Rule 46, there's some language that may suggest that. And I think that they believe that that was in fact the case. And so that's the way the dissent viewed it. They viewed Rule 46 as allowing that. The fundamental problem with that is that's at odds with the Constitution. So it'd be difficult to interpret it that way. At least that's the way the majority saw it. So, but it's clear that the dissent thought you can consider public safety in setting monetary bonds. That they clearly held that.
Yeah. We've only got a couple of minutes, and I know that there are a number of questions that are in the chat that we probably won't get to. A couple of them have to do with whether or not there's going to be any more conversation moving forward about these issues. I would suggest to you that there probably is. It's just that they haven't been posted yet. There's going to be a lot of debate as it relates to the individuals who are running to fill positions on the state Supreme Court, because this was a 4-3 decision. And that means that if there's a change in one judge on the Ohio Supreme Court in the fall that favors the other side, then that means that this may be a very short-lived decision, because it may swing in the exact opposite direction. So there's going to be an opportunity for you to hear both sides and draw your own conclusions as to how that comes to pass. If you hear anything that's coming up with regard to the race for Chief Justice of the Supreme Court and the other Associate Justice of the Supreme Court, you're going to get a chance. And I would suggest that it makes all kinds of sense for you to swing in and listen to those very carefully. I see Judge Scott had put in the chat that she wanted to know how judges are selected in each state, and it says that how they are selected correlates with how things are decided. I know that in New Jersey there's an appointment process that's quite different from the way that we do things here, so that's one of the things that we would have to kind of factor in. And let's see. Is there a list of state amendments up for election this fall? And I think that the only thing we say with regard to that is you have to kind of pay attention. There will be information about the constitutional amendments. Turn it back over to Jasmine.
Well, thank you very much for that, Judge Adrian, and all of our panelists. It was a very informative panel. I saw a lot of questions about wanting a follow-up on the amendments. I do believe that we're planning on having a follow-up conversation, especially piggybacking on what Prosecutor Jordan said about getting out the vote and making sure that people are informed on what is going on. The same way you found out about this, you will find out about our next scheduled event. And I will pass this back to Meredith just for our outro. Thank you.
All right. Thank you to our facilitator, my soror, Attorney Jasmine Jackson. Thank you. Thank you to President Ruth Price Rollins, Basilis Kendrick Jackson, I think I saw you join. Thank you, Vice Basilis Grover Brown. To the other executive committee and executive board members, thank you for your attendance tonight. Thank you to the publicity and technology committees of both chapters. On behalf of myself as chair and my social action committee co-chairs, Cicely Philpott and Denise Rucker Burton, I want to give a heartfelt thank you to our partners in reform, our Zeta Omega partners, Brother Rufus Hurd and Judge Ronald Adrian, co-chairs of the Voter Registration, Education, and Mobilization Committee. Thank you to all of our GCAC and Zeta Omega committee members and chapter members, to all the legal practitioners that joined us tonight, the other attorneys, the amazing staff and advocates, thank you. Thank you to our moderators, our Omega Psi Phi brothers, Russell Ty and Judge Ronald Adrian, and of course our amazing panel of committed, passionate public servants / experts / special guest presenters, Judges Ronald Adrian, Cassandra Collier-Williams, our Delta Soror, Judge Emanuela Groves, and Judge Wanda Jones, to attorneys Carrie Howard, our Omega Psi Phi brother, our Sigma Gamma Rho sister, Aquela Jordan, to Diane Russell, and to Cullen Sweeney. Again, thank you so much. And to you, our faithful audience, thank you for joining us tonight and sharing your time on a 90-degree day as we address a very important topic facing our community: fixing an archaic and broken bail reform system. I also like to acknowledge that we did have Judge Monet Scott on from Cleveland Housing Court, as well as the Village of Woodmere and Omega Psi Phi brother, Mayor Ben Hobart. I think I also saw Ohio Supreme Court Justice Jennifer Bruner on for a while. So thank you all. Upon logging off, you will receive 6 brief yes or no survey questions. Please make sure you complete those so we will have guidance for the future. And thanks again, everybody. Have a great evening. Good night.